Hi, I'm Corky Balch. I work for Getty Images in the Rights and Clearance Department. Basically, I spend my day negotiating permissions with celebrities, properties, artwork, logos, brands for use in advertising and marketing. We're going to talk today just generally about intellectual property rights and third-party rights. Rights to publicity, freedom of panorama, things like that. Quite a dense subject, although it's niche, but hopefully there'll be some food for thought. Hello. Corky, I work at Getty Images. Oh, I'm fall over here. Well done, going well. Working rights and clearance. What does that mean? It means I negotiate permissions with celebrities, logos, brands, artwork, music, rights holders, etc. when our clients, like your good selves, in marketing, design and advertising, want to use editorial imagery in adverts. The reason I'm there is because Getty has a very big editorial business, news, sport, entertainment and archive, and all of this content does not have model or property releases, was not shot for commercial use. So I'm the bridge between our editorial business and our agency business, a bridge which is always burning, and I'm constantly trying to put out. There we go. For the record, I did not write the more glamorous than it sounds bit in the intro on the website Glug, because it ain't at all more glamorous. Copyright. So, hands up who takes photos. Thank fuck for that. Hands up who posts them on the internet. Good, good. Hands up who owns those photos. Keep your hands up. And how many people have read the terms and conditions on Instagram, Facebook, etc., where you post them? 3 people. Excellent. So Instagram's terms, when you post your stuff on Instagram, it gives Instagram the non-exclusive, in perpetuity, royalty-free right for them to do what they want with them, to sub-license them and use them as they will. Facebook's is slightly less onerous. I think Facebook say we'll only use it for our own purposes. I'm not suggesting at all that Instagram want to publish coffee table books with your photography and sell them without giving you any money, because obviously that's not part of their business strategy, because that would be shit, and they're a successful company. That's fine. But the point is, copyright, when you create something, this applies to photos, film, music, literary works, artwork, etc. The copyright protects the creator. You guys who made that, you own the copyright, and you are the exclusive owner of the copyright to do as you will. Up here. Some common misconceptions about copyright I hear a lot. If it's on the internet, it's in the public domain, don't need permission. If there's no copyright notice, I don't need permission. If I don't profit, I don't need permission. No, no, no. If I alter it this way, etc., etc., if I remove it, I don't owe any money. It's all incorrect. I think for me, the most interesting one is that if there's no copyright notice on it, that it's not in copyright. That's not true. You don't need to register something for it to be in copyright once it's created in a fixed medium, i.e. a photograph, a piece of music, a book, an artwork, a painting, whatever. Copyright exists and can be enforced. I'm not only going to talk about copyright because that would be really boring. I want to talk about rights in general and what is behind the copyright, because part of my job is that I work a lot with customers who think that when they license a photo, and I'm going to talk about photos specifically because it's easier to show examples, but the same rules apply to video, and obviously not just licensing video and photos from Getty, but also the stuff which you guys create. But what is covered by copyright for the photo doesn't cover what is in the photo. So if I take a photo of your house, who owns the photo? I do. Who owns your house? Someone said you. Is that you, Danny? No, you obviously still own your house. The fact that I have a photo of it does not mean I have rights to your house per se. So a very obvious example, Chris Hepburn, nice photo of Buckingham Palace. The Queen hasn't signed a model release for this photo, clearly. However, you guys can license this and use it in advertising and marketing. Generally, that's fine. I wouldn't do anything defamatory about the royal family if I were you. But from a rights perspective, it's absolutely fine. And this is a photo, royalty-free, available for all uses. In the UK, we have something called freedom of panorama, which is a provision in copyright law, which means that photos shot from a public place, buildings, and it's modern buildings as well, the Shard, the Gherkin, whatever, can be used in advertising. Again, context is key. Doesn't mean you can take a photo of that building and use it and slag off the company who works there, whatever. But from a rights perspective, you don't need to get permission. What is true in one country may not be true in another. I have this not for the hilarious composition of the bloke kissing the lady in Pisa. I have it for the property. So here's a photo which has a model release. He's signed away his rights, but it doesn't have a property release from the municipality of Pisa. The reason I show it is because obviously a lot of the work we do is social media, online, and it's not geo-blocked. So what you do for a customer in the UK, it may be a customer who has a big reach in another country. And just because the UK has freedom of panorama doesn't mean that Italy has. And in fact, Italy not only does not have freedom of panorama, they have a law called the Code of Cultural Heritage, which protects old stuff. So not copyright is not relevant here. There's no copyright in the Leaning Tower of Pisa. But yeah, no shit, it has protection. If you want to use it commercially, you may need to get permission in Italy. And I show it because we had a UK customer who licensed a photo of the Leaning Tower of Pisa, used it in product packaging, which was global. And guess what? They got a claim in Italy. And it was a claim which could be dealt with, but it's something to think about that, what may apply in one country may not be the same everywhere. And just to look at what's in the picture. The countryside, protected, unbelievably. So this is Val d'Orcia in Tuscany. They have a photographic policy. You have to get permission to shoot there and use these photos commercially. Not in the UK. If you use this in the UK, it's absolutely fine. In Italy, if they see it on social media or whatever, they're going to come and say, you need to give us money. Did you get permission? The same stuff applies, obviously, in the UK and other countries. If you're out shooting in a museum or something with ticketed entry, there'll probably be terms on the ticketing saying what you can do with photos which you take there. Likewise, in public parks. In London, the Royal Parks, for example, they have a very strict shooting policy. So St James's Park, you can get in it any time of day or night. Doesn't got gates like Battersea Park has. But you know what? If you're shooting there and then you want to use it commercially, you need to get a permit. What's the difference between these two photos? It's not a rhetorical question. One's at night, and what do we do at night, apart from all those things we won't talk about? We turn on the lights. So the Eiffel Tower, one at night with the lights on, one in the day with the lights off. There are no copyright issues with the Eiffel Tower. The person who designed the Eiffel Tower died a long time ago. We'll come to the dates on that, 70 years, in a moment. But the lighting display, it's a design copyright, and it's not some quirky French law. It's genuine that there's a copyright exists in that lighting display. And when you want to use this in advertising, especially if the advertising is in more than one country and on for more than a few days, you're going to get a claim if you don't clear it. They're great. The company represent the lights. We deal with them all the time. They're a little bit quirky. They quote things like 40,000 euros. And we say, what, for 2 weeks print use? We were thinking more like 1,000. They say, yeah, that's fine. So why they have a rate card, whatever. But again, it's just what's in the photo. Are there extra rights which may need clearing? Okay, an editorial photo, Christie's showroom in New York. It's an editorial picture. It's talking about, there's an Andy Warhol, Louise Bourgeois artwork going on display, coming up for auction, whatever. It's a photo, editorial use, reporting something newsworthy, matter of general interest, etc. No model property release is required. I have this photo just to talk about, and I was desperately trying to think of a made-up scenario where someone would use this in advertising. Like an interior design company. That's desperate, isn't it? But whatever. I have the photo to ask you guys how many different rights, apart from the photographic copyright. So who's it by? It's by Don Emmett, who works for AFP, the French news agency, who Getty represent. So you can come and license the photo from Getty. So I've licensed the copyright. What other rights do you need to think about when using this photo? How many?
4.
Good guess. 5. There's the property itself, Christie's. There's no property release, so they need to be thought about. There's the man. He hasn't signed a model release. There are 2 artworks. There's the Andy Warhol, which is in copyright. There's the Louise Bourgeois spider in copyright, and there's also the Coca-Cola logo, trademark. So that is not only a dress design, which is the shape of the bottle, but also the name itself for trademark. So there's 5 different rights there which you need to clear. In other words, this photo is a really shitty photo for commercial use. But again, it's just looking at what's in the picture beyond the copyright. Very quickly, difference between Edvard Munch and Andy Warhol, Louis Bourgeois. So copyright for artwork generally exists for 70 years after the death of the artist. Other copyrights, it does vary territory. Literary and music copyrights do vary, but artwork generally 70 years after death. Munch went copyright a couple of years ago. Andy Warhol died in the 1980s. Louis Bourgeois, I think, about 15 years ago. But these guys, very much in copyright. This guy out of copyright. However, it's not just the copyright. In Europe, we have moral rights. Moral rights last forever. And moral rights protect things like attribution. So you need to credit an artist. You can't make out it's yours. Right to integrity. You can't do pornographic things with the poor screaming person. I mean, you could do, but you may get into trouble. So, not just properties, people have rights too. Alicia Vikander, Hollywood actress, right to publicity, this is called. So right to publicity is what the legal recourse you have to monetize your likeness, your name, your voice, and other facets of your identity. The reason I have this photo is because there's a classic one which crosses my desk, not this one specifically, but photos like this, for agencies doing social media stuff and PR work for brands. So Yves Saint Laurent bag, massive brand, like to do lots of PR and advertising, like to use celebs. They have some brand ambassadors, but they can't just use this photo. Okay, license a photo from us, but they really need to talk to her agent if they want to use it in any kind of advertising context. Because I don't know, what if she is a Gucci brand ambassador? That would be pretty bad. But again, they need to talk to her agent, which is something which I do. But again, if it's social media or PR and it's up there for one day or something, if you license the copyright, fine, and you may get away with it. But much better if Yves Saint Laurent actually talks to her and give her 10 free expensive bags. Then she may say yes. Football, Lionel Messi, massive brand endorsement deals. These are two photos which were asked for by one of his the brands he endorses, a drinks one. It's a really tricky photos though, because when they're saying, I want to use it for all advertising packs, I want to do all sorts of stuff, it's like, what are you going to do with the logos? They need to talk to Barcelona Football Club because they have a relationship with Nike, whereas Lionel has a relationship with Adidas. He re-signed with Adidas last year for I don't know how much, but a ridiculous amount of money. And, there's all these other logos, all the logos in the new camp and the stadium where Barcelona play. There's all this other stuff they need to think about. And again, it's just to say, look at the picture, what's in it. And it's not just pictures you license, it's what you shoot if you're out and about. If you haven't got the money for Lionel Messi or Alicia Vikander, why don't you have a dead brand ambassador? Cheaper, still expensive, but certainly cheaper. Laws around the world, they vary different country to country in terms of rights to publicity. I show these ones, obviously the same advertising campaign, legend of our time. But with the way that the law for rights to publicity is different. So in the US, it varies state to state. They don't have one federal law. So James Dean died in California. That California state recognised the right of publicity for 70 years after death. He still has an enforceable right of publicity. You need to clear it of his estate and have a very active estate who charge money to use his likeness in ads. Marilyn Monroe also died in California, but she was born in New York. And the lawyers for her estate, in their wisdom, decided to domicile her in New York for tax purposes because New York state at the time didn't have any death duties, whereas California has massive death duties. So they thought, well, save some money. However, New York State doesn't have a right to publicity after you die. It doesn't recognise that. So guess what? Legally, you don't need to clear the use of her likeness. Doesn't mean she hasn't got an estate, who are lovely people. We work with them a lot on other brands they represent. But it's just an example where, again, it's not all, it's nuanced, basically. And the fact that different rights and legislation varies country to country and in the US, state to state. Cautionary tale. Sorry, this is crappy resolution. I nicked it off the internet. We can cut that out of the video, hopefully. So you don't have to be famous to have a right to publicity. This is the story of Lindahl's Dairy in Sweden, who used this photo from a photo agency in Sweden, thinking it had a model release. It didn't. And they're advertising a Turkish yogurt, product packaging. Turns out this is a Greek man, and was not particularly chuffed, best pleased to be on a Turkish yogurt. They settled eventually for $250,000. They got their fingers burnt, and in a statement they said, "We, in our opinion, we respected all the rights of the photographer." Doesn't cut it, because they did respect the rights of the photographer. They licensed the photo, but they didn't check. And I think, to be fair to the client here, they were told that, yeah, we got a model release, but they didn't, as it turned out. And their license for the copyright didn't make any indemnities for the man. So they got it done. Cautionary tale. One more, not a cautionary tale, but an example of copyright and reproducing copyright. So there's a photo, again, it's an AFP photo, the French guys we rep. It's Bambi, the street artist. Our legal department had a claim from Bambi's legal people demanding money for copyright infringement, saying, you can't have this picture of Bambi's artwork, because although it's graffiti, it's artwork. She's an artist, yeah, it's protected as much as any other artwork would be. They said, yeah, US money. We're like, it's editorial, it's content, it's, remember the public interacting, there's other tags, whatever. But then our lawyers were looking and going, wait a minute, her graffiti looks mighty familiar. Lo and behold, here's a photo by our staff photographer, Chris Jackson, which she's completely copied. So the conversation turned around. It's like, we think actually you've infringed our copyright, not the other way around. It was resolved very amicably. And I will say no more about that. But again, it's that's it in terms of the pictures. I think the main point I'm trying to make is just look at what's in the image. And as I say, it's not just photos, it's video. It's what you guys shoot when you're out and about. Even if you're shooting on a closed set, what's on the wall in the sitting room, the bedroom, posters, artwork, whatever. T-shirts, got brands on them. They're all trademarks. And there's countless stories of brands getting into trouble for advertising using rights which haven't been cleared. So think about it. That's all. Thank you very much.